Hello and good evening, everyone. Welcome to today's webinar on delay and disruption claims in construction, key takeaways from landmark judgments. I am Devesh Matta, an associate with MRP Advisory, and I'll be moderating this discussion with our esteemed panel of experts. Construction projects involve multiple stakeholders, tight deadlines, and significant financial commitment. Delays and disruption, dare I say, are almost inevitable, leading to dispute over time and cost overruns. The way courts and arbitral tribunals handle such claims has evolved over the period of time significantly. Today, in this webinar, we hope to explore the difference between delay and disruption claims, concepts such as concurrent delays, key legal precedents, common pitfalls in delay analysis, and the role of expert evidence in resolving dispute, how arbitrators assess delay claims, including the legality of no claim certificates, best practices in record keeping, and more. Now, before we dive into the discussion, let's quickly go over how today's session will unfold. We will begin with panel questions. Following that, we'll open the floor to audience. We aim to keep this session engaging and hope to conclude it within an hour. We encourage you to share your thoughts in the chat and ask questions throughout, which we are going to take up at the end of the session. Now, without further ado, let me introduce our panelists who bring in wealth of experience and insight into this discussion. We sincerely thank you all for taking the time to be with us today. Our first panelist is Ms. Gunjan Chhabra. Gunjan is a dual qualified legal professional admitted to the bar in India and as a solicitor in England and Wales. She is a partner at MRP Advisory, leading the dispute practice in India. With several years of experience, Gunjan has advised on complex construction disputes and arbitrations, appearing before courts and tribunals globally. She has been recognized for her leadership in the legal field, including the Pioneering Women Leadership Award from ET Now. Welcome, Gunjan.
Thank you, Devesh. Thank you so much.
Next, we have Mr. Manoj Kumar, legal and corporate governance expert with nearly 18 years of experience across India, the Middle East, and Africa. He is the AVP Legal and Contracts at EFKON India. A law graduate from Delhi University, is also a qualified company secretary and an alumnus of IIM Lucknow. Mr. Kumar brings in deep expertise in corporate legal matters, contracts, M&A, arbitration, and litigation. It is great to have you here with us, Mr. Kumar.
Thank you, Devesh.
Joining us from Dubai is Professor Stephen Hibbert, a highly experienced arbitrator with over 40 years of experience in dispute resolution. He has served as an arbitrator in over 40 arbitrations across Australia, Asia, and the Middle East, including high-stakes ICC arbitrations. Previously, he was a general counsel for Qatar Rail, overseeing legal matters on one of the most largest and the world's largest infrastructure projects. Ranked among the top 10 commercial arbitration lawyers in Asia, Stephen brings unparalleled expertise to our discussion. We welcome here you, Professor. And finally, we have Mr. Mohamed Hamza, Associate Director at Boultwood+Associates, specializing in dispute resolution for major construction projects. With a civil engineering background, Mr. Hamza has significant experience in planning and delay analysis, supporting expert report and high-value arbitrations worldwide. His expertise spans industrial, infrastructure, residential, rail, power, and oil and gas sectors, particularly in the Middle East. Fluent in Arabic and English, he offers key insight into project delays and disruption claims. Glad to have you here, Mr. Hamza.
Thank you, Devesh.
With that, let's get started. I'll start with you, Gunjan. Delay and disruption are two terms that are regularly used in the same breath. Can you differentiate between delay and disruption claims in construction disputes?
Devesh, thank you so much. I think this is a very pertinent question, particularly to start off the webinar with. So, of course, these two terms are often used interchangeably. But if we look at it from a construction contract perspective, they mean two very different things. So firstly, when we talk about the meaning itself, in a construction project, a delay is often referred to the works being affected by events which have a critical impact on the progress which implies it is something that will ultimately change the completion date of the project. A disruption, on the other hand, could be a short sort of a disturbance, a hindrance or interruption, and I refer to the Society for Construction Law Protocol when I speak on this. And this may be caused to a contractor's normal working condition, which leads to loss of productivity. So if we look at both from the meaning perspective, disruption focuses essentially on the efficiency of work itself, and delay centers on the impact of the project completion. Say, for instance, the manner in which the site is handed over to you. If it's done in a piecemeal basis, it could be a disruption to begin with. The second point of difference, I would say, is the impact it could have on a claim. As for delay, if it is caused by the employer, then the contractor becomes entitled to an extension of time and costs in some cases, but not necessarily. On the other hand, if it is caused by the contractor, if the delay is caused by the contractor, then the employer becomes entitled to liquidated damages, usually, which is provided in the contract itself. And when we talk about the claim of a disruption issue, if we talk about disruption claims, then such claims don't essentially entitle contractors to extension of time, but they may entitle a contractor to, say, additional costs or compensation that may have accrued due to the said disruption. And of course, everything will ultimately depend on the contractor's ability to be able to show whether or not they've taken measures of mitigation. And lastly, before we look at it from another perspective, there is, of course, an interrelationship between delay and disruption, and they can't be seen in vacuum. And if, say, a disruption event is very prolonged, then it will ultimately lead to a delay in the project timeline itself. So then it would be interrelated in that sense itself. For instance, if we take an example of a revision or a delay in approval of drawings, it would begin with being a disruption event alone. And in the sense, it would cause a loss in productivity to the contractor. But if it's prolonged over a very long period of time, ultimately it will have an impact on the critical path of the project, and then it would become a delay event. But of course, the complication arises when there are more than one event which causes the disruption and delay, which is usually the case in construction contracts. And that is where the role of a claims assessment professional or an expert witness in that field comes in. So, maybe someone else would be a better speaker for this particular aspect of the difference between the two.
Right. Thank you, Gunjan. Talking about a claims expert, Hamza, would you want to add something to this from a claims expert perspective?
Yes, from a claims perspective, as Gunjan said, it's mainly the delay affects, it's about time, and disruption is about productivity or inefficiency. As I wanted to give a simple example to differentiate between delay and disruption. If the contractor suffered from hard conditions or unplanned hard conditions when he was carrying out the works, but the project was complete on time, this is disruption. But if the project finished late due to an issue, this is delay. So both are different, but disruption may or may not cause delay in the end, as Gunjan said, when it disrupts the critical path to the project. And the last thing is that we measure disruption by two recognized methodologies, which is a bit different than delay. It's the measured mile, which compares the normal productivity versus the impacted productivity, and the earned value analysis, which compares the planned performance against the actual performance. And these are the mostly common used methodologies.
Right. Can you also tell us how crucial is expert evidence in delay disputes? And how do, tribunals assess competing expert reports when determining delay responsibility?
Yes, of course. It's the delay expert report is important because it simplifies the delay disputes to the tribunal. because delay disputes are technical disputes that involve complex delays, and they depend on multiple factors such as the contract terms or the project schedules, and the also delays that occur during the project. Also, the delay expert has to provide an independent opinion to assess the delays and the impact on the project, and analyze the impact on the project, and also identify the responsible party. And finally, as a conclusion, the tribunal rely on the delay expert's opinion to conclude the entitlement of the extension of time associated with the prolongation costs, if exists, or if the extension of time was rejected, it will be to assess the liquidated damages. I think these are the main points, or the main important points for the delay expert report. And for the second question, I think the tribunal assessed the delay expert report based on multiple factors, and the first one and the most important one is independence. As we said before, that the delay expert opinion should be independent, and if the tribunal felt that the delay expert or the expert has a biased opinion, or this opinion advocates for a specific party, this would lead to dismiss the expert's opinion. The second point is the method used. So the methodology, delay analysis methodology used should be a recognized methodology by SCL protocol or AACE. And it should simplify and make the complex delay understandable to the tribunal. And the third point is the factual basis. And this is a key element in any delay analysis. A well-supported report is a strong report because it bases its opinion on facts rather than assumptions. So the main important point is records, and contemporaneous records include progress reports, minutes of meetings, correspondence. All these things the expert should rely his opinion on, and it helps the tribunal to understand the dispute. And the final point is the clarity and contradictions. So I think the report should be well structured and clear and understandable to the tribunal, and also the expert shouldn't contradict himself in his opinions. I think these are the main four points.
Right. Thank you so much, Hamza, for your insight. Talking about the assessment of the tribunal, Professor, having served as both a lawyer and an arbitrator, how has your approach to handling delay claims differed between these roles?
I'd just like to commend, thank you. I'd just like to commend Mohamed Hamza for what I think was almost a perfect answer. If you're not lecturing at a university, you should be lecturing very soon, because what you said, everything you said was completely correct. What I would like to add from a tribunal's point of view, though, is that the difference in proof and analysis of a disruption claim is very, very different to a delay claim, because the proof of a disruption claim can be very complex. It requires a sort of a look forward or look back test in terms of if the contractor had used the methods that he was going to use to construct whatever it was, but he was disrupted or interfered with or had to change his work methods, would he still have made the same progress as he planned to, and should the employer be liable for the additional costs of the disruption? And that's quite a complex evidentiary issue to work through for a tribunal. What Mr. Hamza said about delay is completely correct again, and that is that it's based on contemporaneous records and an analysis of the competing critical paths and the before and after. There's a lot of discussion in the market as to what should go in a contract. I might just make this point now as to the form of delay analysis and the form of analysis for delay claims during the course of the contract. And some practitioners, and I'm not being critical, some practitioners like to specify a time impact analysis I don't know, Mr. Hamza, if you've seen that in some contracts, that people step forward and put in the delay claim shall be accompanied by a time impact analysis at the time. I've had quite a few cases where that step has been taken in the drafting of the contract, and it hasn't happened in practice because, as we all know, delay claims classically are always submitted at the end of the project when things are finished, and you can't really reconstruct a time impact analysis at the end of the project. So as a suggestion from a tribunal member, I would say just leave the form of delay analysis out of the contract and let the parties deal with it as they do at the time. There can be competing views, whether they're using Primavera or whatever programs they're using and how they do it. In terms of evidence, one of the problems for tribunals these days, and it is a very real problem, and that is just the mass of paperwork that these projects generate. And so, although Mr. Hamza said like project control documents and contemporaneous records, the contemporaneous records that exist on major projects these days, could fill a couple of football stadiums. On the Caddo Rail project, where I was on for 8.5 years, it was the most well-documented project I've ever been associated with, including full camera takes every day of every part of every work site. And so if you started to overlay, we had a few disputes, to overlay the contemporaneous records was a very big job. And I think that some practitioners in arbitrations think the best thing to do is to just wheelbarrow all the documents into the tribunal and let the tribunal sort them out. Whereas you get a better result with the tribunal if you could give them just the core key documents and the core key records and take them through, again, as Mr. Hamza said, a nice lineal analysis of where the delay occurred and how it affected the critical path. So I hope that helps. Thank you.
Right. Of course, Professor. Thank you so much for your response. I would like to come to you, Mr. Kumar. From your experience, what practical steps can parties adopt in contracts to minimize disputes over delays?
Yeah, thank you, Devesh. I simply, let me first, before diving into my personal experience, I would like to share 2-3 interesting fact about EPC contract. One is that a study shows 87% construction project either experience delay or overrun in some way. So this is the one of the interesting factor. It's established that in construction, delay is inevitable most of the time. Second, if there is a litigation, then litigation cost would be somewhere between 5 to 8% of the total project cost. So this no one can deny this fact that if there is a litigation to project, it harms project itself, the contractor as well as the employer, and at last it is detrimental to the economy at large, except one group of the people, that is legal firm like MRP Advisory. So on the lighter side, this now coming to my personal experience. What I experienced, that if the contractor recognize the fact that the process of contract is not a start from the date of submission or receiving of LOI or award, but from the date of tender is floated. So if tender is floated, then if that contractor has decided to participate in bid, then they can evaluate all the risk relating to delay and disruptive risk in the contract in the advance, and they make a strategy to mitigate either at the time of the factoring the price in the contract price itself, or later on during the execution of the project. So according to me, there is some example I have, and also I have experienced that this factor, if contractors simply adhere this one, there is a chance to reduce delay dispute by more than 50%. Yeah. Another is that in contract, there is a administrative preconditions are given. For example, there is a notice to be served within the particular timeline, and there is also conditions. For example, one of my project, there is a clause of prolonged suspension. If there is a suspension more than 84 days, then it would be contractor has right to notify it to the engineer for the purpose of omission. And and after that, if engineer is not giving their feedback or their consent within 28 days, then that work would be treated as a omission from the contract. So most of the time, because contractor is busy in one or another things, they ignore the that administrative preconditions given in the contract, and that leads when the dispute goes to the first stage dispute board, or it will goes to the arbitration. It will very difficult for the contractor to prove their claim or defend their claim.
Right. Thank you. Thank you, Mr. Kumar, for your input. Next, I would like to come to you, Hamza. What do you think are, common pitfalls that you usually notice in a delay analysis that weakens a party's claim?
Yeah, there are several actually. But I mean, the common pitfalls that I usually see are I think I can summarize them in 7 key points. And to start with, the first one, it's the use of unreliable baseline program. If the baseline program was never approved, or it was unrealistic baseline program, this means that the basis of the delay analysis is weak. And of course, the claim itself will be weak, because the baseline is the reference point that we measure the progress and the delays against. So it's a core element in the delay analysis. The second point is the incomplete as-built data, which will return us to the contemporaneous records again. It's one of the key elements, of course, in any delay analysis. And if there is a lack or a manipulation in this as-built data, this would also undermine the claim, the delay claim. The third point is the failure to link the delay events to the critical path. So if the claimant requests an extension of time, he has to prove that at least one delay event or more had an impact on the critical path and therefore the project completion. But if the claim report includes or focuses only on non-critical delays, this would lead to a rejection to this extension of time and the claim. The fourth point, I think, would be the ignoring the concurrency. So concurrency, if both parties contribute in delays that are on the critical path, either in parallel or sequential, these delays have to be considered by the claimant when he's preparing his claim report. It cannot be ignored, or either it will be just a biased opinion or ignoring facts. And also this would undermine the delay analysis calculations coming out from the claim. Then the fifth point is the wrong selection of the methodology. So the delay analysis methodology should consider the project complexity and the project status. The project status means if the project is complete, we should consider a retrospective analysis, like such as planned v as built, or as built longest path, or collapsed as built. But if the project is still live, it's either a TIA, time impact analysis, or it's an impacted as plan, which should be rarely used. Then it would come to the misapplication of the selected methodology, which is very common. To give an example, I'm assessing currently a claim for a project which is already complete since 2019. and the claimant applied for his consolidated claim and impacted as planned. So this is totally, I mean, irrelevant to the status of the project. So, and the application of the methodology itself, it's wrong. So also this would undermine the claim. And finally is the failure or the lack of cause and effect. And this is a very common point when you find the claim report is full of arguments, but it fails to link a specific delay event to a specific impacted activity. And if this failed to happen, it would be considered a global claim, and probably it will be rejected. So I think these are the main seven pitfalls that I usually see. Yeah.
Thank you, Mr. Hamza, for your insight. Gunjan, one of the most significant concept, also one which is the most difficult also sometimes. What do you think is the prevailing approach of law regarding concurrent delays and apportioning responsibility in that regard? And if you would share some landmark decisions with us in that regard, that would be really helpful.
Thank you, Devesh. I'll actually take cue from what Hamza just shared. Concurrent delay is one of the key elements of having a good expert report as well. And it's also legally a key element to be looked into when you are looking into delay or disruption claims. So if we talk about from a construction claims perspective, essentially a concurrent delay would be a delay which would have three main elements. First, that there should be two or more delay events which affect the project timeline at the same time. Okay, number one. Number two, one or more of these events has to be a delay event which is caused by the employer, which means it's an employer risk event. And one or more of the event has to be a contractor risk event. And number three, each of the two or more events must be an effective cause of delay to completion, meaning that they should be critical path. I think some of this has already been covered by Hamza, but these are the three main points which deal with what a concurrent delay is. Again, coming back to your question, concurrent delays are relevant to look at essentially because, they do deal with apportioning of number one, the responsibility of the delay, who of the two, contractor or the employer, is responsible for the delay. And number two, the costs associated with the delay also come about as a cause of the concurrence of delay. So here, although you also, asked your question with regard to the authorities on this subject. So although there are quite a few authorities, probably not so many in India, but across the globe, there are quite a few. And I will be dealing with two of them right now. So first is, of course, the very celebrated Malmaison judgment, Henry Boot Constructions versus Malmaison. This is a 1999 judgment of the UK Technology and Construction Court. And it talks about what happens when there's a concurrent delay. So legally speaking, it says that even if there are two events which cause the same delay concurrently, and one of them is such that the contractor was contractually responsible for it, it will still entitle the contractor to an extension of time. Okay. However, now this is where it becomes interesting. When you're calculating cost, which is arising out of a concurrent delay, even if the contractor is able to show that, look, the dominant cause of the loss was an employer delay, but there was another cause of loss which was not an employer delay, which is the contractor's risk event, then his claim will fail unless in a concurrent delay case, the contractor is somehow able to show that, look, had it not been for the employer's delay, I would not have incurred this cost at all. So essentially, the employer's risk event has to be the only event which is causing the loss to the contractor to be able to enable the claimant to sort of succeed in that claim. And the Malmaison judgment, among other jurisdictions, has been applied in the Indian context as well. There's a 2019 judgment of the Madras High Court as well. But there is also a 2022 judgment of the Delhi High Court. And that essentially deals with apportionment. And they had taken a sort of notional approach. So this judgment is EFKON versus GPT Rahi. In this, what they had done was that the arbitral tribunal had ruled that there was an inordinate delay on the part of EFKON, who was the claimant, the employer, in handing over of the site and the good for construction drawings. But there were some obligations on the part of the contractor also, which was delayed, and they related to sort of furnishing of the performance security, the mobilization advance and such. And these delays were also concurrent. Okay, so now the AT applied the principles of apportionment, and they concluded that half of the delay could have been apportioned to each party. And in view of this, half of the idling costs of the labor and the machinery were allowed by the arbitral tribunal. And so it was essentially what they held was, look, half of the delay is attributable to the employer, half of the delay is attributable to the contractor. So on a notional basis, we are going to award you half of the claims. That's how they had apportioned the claims in a case on concurrent delays. So yeah, those are the two judgments which I wanted to speak about.
Right. Thank you, Gunjan. Mr. Kumar, a lot of onus is on the contractor to prove his claim or to, the burden of proof or the onus is on the contractor. Considering that, how does your company approach record keeping to support or defend against delay and disruption claims?
Yeah, Devesh, record keeping is one of the documentation and record keeping. You cannot separate these two, and both are very essential. You can say sine qua non for maintaining or defending any of your claim before arbitral tribunal or whether it is dispute board. So that is one of the no one can deny. Secondly, this with regard to record keeping, there is a means if record keeping and documentation, if any matter goes before tribunal, so there would be the litmus test for your record keeping and documentation, because all the documents, all your claim is based on the documentation. They believe in that, means what you have communicated with your client, what was the means if you communicate with your client, and if you present anything afterthought before the tribunal, then it can be traced from that document itself. So record keeping and documentation is vital aspect, and without that it cannot be any claim cannot be defended or claimed before the tribunal or dispute board. Second, this every company has their own approach to means they are maintaining their database, they are implementing the document management system. So we are also customized DMS system in our place. So that is the one. There is a limited access to the limited people as per the requirement. So that provide the flexibility to record keeping and take the data and use the data as per the requirement. This is the one. Second, there is a unique system in our company, and that system, our every project there is a governance board. So governance board is taking care of all the project, time to time review, and they submit their report to the board. That our board is in the Europe, Austria. So that is the means robust one of the system. So if we get any project, then the first meeting before the tribunal and before this governance board, so they ask one questions, and that questions solve the many problem down the line. First problem that solve, it provides opportunity, or you can say compel the project manager to identify or evaluate all the risk before beginning of the project. That is the one. So I will come to that questions, that magic question, and that also provides the project manager or the other stakeholders to maintain cash flow. So if project cash flow is as per the milestone given payment milestone, then project is in the healthy state. So that also give the idea, means that helps to the maintain the cash flow. And third, that it also helps the team, the document manager and the project manager, to don't give any relaxation to documentation, because that documentation will help to defend the claim, delay claim later on. So that magic question is, that first questions that that compels everyone to act upon is that why cannot the project be completed 3 months before the project schedule? So this question, for answering this question, the project manager, project director go into detail, every detail, and only one question in first meeting it is handled by the team. So there is a lot of discussion, all the provisions are taken care, all the difficulties that would be anticipated, that has been recorded, and there is a minutes will be created to that meetings. It runs about 30 to 40 pages, and that documents become sacrosanct. And every time that documents, if delay occurred, delay log is recorded or that is shown, then it is very difficult for the project manager to defer their statement from one meeting to another meeting. So that question help us to maintain all the, means record keeping, also maintain the cash flow and anticipate the delay and disruption events in order to plan better and bring the project in profitability.
Thank you, Mr. Kumar. And hopefully this would help the other contractors to, in their endeavors to uh, keep their records well. One topic, Professor, I am very interested in is the concept of no claim certificates, which has been in vogue now. So, how do arbitral tribunal assess the validity of a no claim certificate, which are usually signed under coercion? And these are done such as to avoid liquidated damages. And once these no claim certificates are signed, can the contractor still pursue claims for prolongation cost after signing such waivers? You are on mute, Professor.
Yes, I'm not sorry, mute button. Look, thank you for that question. Can I just go back to the concurrency topic just briefly? I know we're on the time limit. Every delay on a project is concurrent with something else. The concurrency issue is the go-to defence by most employers, and I'm not being critical about that. I acted for an employer for 8.5 years on the Doha Metro project. The concurrency issue is the go-to defence on most delay claims, but it's quite a complex one. And I just want to thank Mr. Kumar for mentioning before in the previous answer that really the concurrency as an issue was given birth to at the time of the tender in terms of what's in the contract. And at that point, the bidding contractor, although it's quite difficult to amend the general conditions generally, has to have a look at what is permitted as excusable delays in say, Clause 8 of the FIDIC sort of general condition, and decide if there's going to be a submission that they should be expanded or changed. But concurrency does not become an issue until the contractor is parked with an excusable delay, and then the employer will say, yes, you've got an excusable delay, but you were concurrently delayed by your own works, et cetera, and therefore the two run in parallel, and therefore you're disentitled. So it's important that everybody understands that concurrency is only an issue when there is on the table an excusable delay for the contractor. And the contracts I've been seeing over the years, more and more and more are crossing out the permitted excusable delays. And they're getting less and less and less. So it's a point, the whole issue in my experience about concurrency is a tendering, bidding, negotiation point at the start. And that's where it starts and finishes, because if you get that right, you can manage concurrent delays. In terms of your question, thank you, Devesh, about sort of what the Americans call quit claims, what the British and Australians call settlement agreements, some form of documentation that brings them to the end. From a tribunal's point of view, one of the things that I'd like everyone to just be clear about now, that is that whatever the tribunal thinks about these things, and whether they've been, strong-armed or however they've come about, the fact is that they're evidence, and a tribunal's duty is to make a decision based on the evidence that's put before it. So if somebody puts before the tribunal a quit claim or a settlement agreement or some sort of, and it can be for, not for the whole contract, it can be for a variation, or can be for, I've had many of those. We documented those on the Doha Metro project. Every time variations were settled, there's a little piece of paper that said they agree that this is the settlement amount for that item, et cetera, et cetera. If they're tendered in an arbitration as support for the fact that this claim has been settled, or these claims, it's very difficult for an arbitration tribunal not to give that party the benefit of the document and what it says, unless there's evidence. And it's really not for corporations to bring, easy for corporations to say that we were strong-armed into doing this, we really shouldn't have signed it, et cetera, et cetera. So the simple answer to your question is that everybody should proceed on the basis that these settlement agreements, quit claims, are effective and valid on their face in terms of what they say, and that they will be upheld by a tribunal. And that's the most sensible way to proceed on these things.
Right. Thank you, Professor. Thank you for your inputs. That wraps up our first round, which were the panelist questions. We have received a lot of questions from our audience. I thank them to be, they was engaging with us throughout the webinar. The first question, and why don't Mr. Hamza, you take it. What are the major challenges you face when you prepare a claim for delay in construction?
The major challenges is the lack of contemporaneous records, and also the contractors sometimes provide unrealistic delay events and claim and the claim become exaggerated. So when you're preparing a claim for a contractor, you need to rely on realistic delay events and link them to the correct impacted activities, and your source would be the contemporaneous records. And in order to have him on board, you need to involve the claimant with the impacted program as well when you are preparing the claim. But the main challenge in most of the project is the lack of contemporaneous records. I mean, most of the projects, yes, they have a baseline program, but this program is not updated regularly. Or if it's updated, you will find the program is changed and revised, and it's totally a different update later, or a totally different revision. So you cannot utilize these updates in your analysis. So that's the main challenge. It's the progress updates, actually.
Right. Thank you, Hamza. Thank you for the insight. My next question, Gunjan, you would be the most ideal person to answer this. Does grant of extension of time automatically entitle the contractor to prolongation cost, or is a separate burden of proof required to establish any sort of financial entitlement?
Devesh, thank you so much. I think we've spoken quite a bit about this issue as well, that grant of extension of time will not automatically entitle a claimant to a cost claim. There will, of course, be a lot of other issues which will have to be seen. So, for example, even if there's not a concurrent delay, and if it's a pure delay as well, which is an employer risk event, there will still be the issue of showing the breach by the employer, which is it's an inexcusable delay on the part of the employer, number one. Number two, that the impact of the breach was in fact that there was a delay in completion of the project. And number three, that the delay in the project did in fact have an impact of costs on you. And then you would have to, of course, prove the quantum part of the costs as well. So it's not a simplistic matter of mere extension of time leading to a compensation claim succeeding. In fact, there was a recent judgment by the Delhi High Court as well in 2023, which was National Highways Authority of India versus IRB Pathankot. And in that judgment, this issue was specifically dealt with. That judgment, the contract clauses very specifically provided that look, to be able to succeed in a claim for compensation on account of delay, you will have to show, number one, that there was material breach on the part of the employer, and number two, that the material breach led to a cost impact for you. What the arbitral tribunal had done in this particular case was, without looking to the issue of material breach, simply on the aspect of an extension of time entitlement, they had also granted the compensation claim. So such a finding was held to be contrary to the contract conditions, and the High Court ended up setting aside the award. So essentially, yes, the second factor would be to look into your contract clauses, not just about the causation and the effect and the proof of the claim itself, but of course, very carefully to look into the contract clauses as well.
Thank you, Gunjan. Mr. Manoj, this question is for you. And we want to know that if the project has been delayed due to increase in quantity variation, I suppose, what sort of records does your company maintain in that situation, in that particular situation? You have spoken a bit about record keeping, so it would be an addition in addition to that.
Yeah, first of all, quantity variation. If quantity variation, there is a limit given in the any contract. It is up to 25% minus plus. So up to that extent, it is the contractor can claim the rate that quoted for that job. And after 25%, then there is a mutual discussion between the parties, and they arrived on the rate. And then thereafter, if they not arrived and not mutually decide, then there is a certain set of documents are given, reference is given in the contract, that you refer to this one, this guidelines. So here key point is that 20 means whether the quantity variation is within 25% or it is exceeding 25%. So that is the one aspect we need to take care. From the point of view of the record keeping, so here record keeping is that you have to write the correspondence with the employer if there is any variation to that limit, and later on if there is any dispute, you can produce that documents at right time.
Right. Thank you, Mr. Kumar. This question is for you, Professor. If an arbitrator, quite an interesting question, if an arbitrator had to select a claim expert, what are some of the factors you would look into if an arbitrator were to select a claim expert? You are on mute, Professor.
If I've got the question correct, it's a very topical issue. I'll tell you why it's a topical issue in the sense that there's quite a different view in arbitration tribunals that are constituted under common law jurisdictions and under civil code jurisdictions as a principle, and that is that in the civil code system, it's very common for tribunals to, through a process with the parties' consent, to appoint an expert for themselves who sort of reviews the competing expert reports. In the common law jurisdiction, it's very, very rare that happens because the courts here in the civil code systems, the Middle East and in France, of course, they and Egypt and places like that, the courts appoint their own experts and are very much guided by the expert reports on technical matters. So to answer your question, there's a growing, and I mean, Mr. Hamza, maybe you can contribute to this, of course. There's a growing body of discussion that many experts, and I say this with all kindness, are becoming too biased for their own clients and too openly biased. And Mr. Hamza picked this up. It was his very first point about experts, and that they have to be independent. And although they say they have to be, although they have to be independent, and although they sign a piece of paper and document that says we are independent, you can very quickly see biases come out. And I'm not being critical. I'm just saying that to all my expert listeners today, that tribunals can detect very, very quickly if an expert is favouring their client whenever there's an issue, et cetera, and that dilutes the value of that expert's testimony. So there is a case, as I said, a growing discussion that in very complex cases, the first thing you have is caucusing. It's called hot tubbing of the experts and put them together to see if they can produce a joint set of findings. That's very constructive. But even in that process, sometimes you'll find that experts just refuse to agree. So there's a bit of a professional gap between them, which just is maintained because they're not completely independent. And there's a growing body of discussion to say that the tribunal should, in very big cases and in very complex cases, in terms of delay, complex, delay cases, have the benefit of their own expert. I've been involved in a couple where we've done that. It's been very successful. A couple where the process of trying to appoint an independent expert for the tribunal just got bogged down in technicalities and history and did they have conflicts and could they be agreed, et cetera, and it just didn't work. But Mr. Hamza, have you had an experience, may I ask, where you've been involved with a tribunal where they have appointed an expert themselves?
Yes, it's actually in Dubai, and
yes.
It increased actually the debates. So instead of 2 debates, now it's 3 debates. So and it's
and
I think the expert had 5 rounds of reports.
5 rounds?
Yes, 5 rounds of each delay expert, issuing 5 rounds of reports because the first report and the second report, it was the 2 experts responding to each other's. Then the tribunal appointed their own expert, and he issued 2 reports. So after that, each expert issued 2 reports. Then he replied with the final report, and the same as the expert. So I understand that it's very complex delays, and sometimes the tribunal would require a third independent party from his side, but also it increases the disputes and the uncommon ground between the experts. So it's
I guess the answer is
pros and cons.
Yeah, the answer is I think if it Mr. Devesh, if it works well, it's very valuable. But it can be just, as Mr. Hamza just said, it can be just the source of an increasing amount of disputes, where each side wants the right to appeal and object to and respond to, and that's the practical problem. Because if it works well, it is incredibly valuable for a tribunal to have someone in the middle and retained by the tribunal who basically does the filtering and assessment of the competing expert reports. So it is a very hot topic at the moment, but nobody seems to have a solution, easy solution.
Just to add to the discussion which Stephen and Hamza were having, Stephen, I have come across, in fact, increasing number of tribunals where they're choosing to appoint their independent experts, and that is actually stemming from the issue of partiality. So I believe that doubt has crept into the mind of a lot of arbitrators relating to how the claim experts are taking their client sides increasingly. And I have actually come across tribunals which have begun appointing their own experts. So definitely happening.
I mean, if I had to cast a vote, I would say that I'm in favour of it if it can be managed properly. I think it can add a lot of value to the tribunal's work, because otherwise you've got, and it depends how the tribunal is constituted. I know we're on a time limit, but if the tribunal consists of, which they always should, they should have a civil code lawyer, someone else, and an engineer or somebody that understands the project. Many tribunals have become dominated in major cases by lawyer, and I'm finding that quite difficult, because then they are left to decide all these technical delay issues with no help. So you can get at it by way of possibly having a good delay guy in experience on the tribunal. But if you've got 3 lawyers on the tribunal, you really do need an independent expert to assess the technical analysis, if you can get it.
Absolutely. Absolutely on point.
Right. There are a lot of more questions, but I am conscious of the time. So you can reach out to us for any queries. I extend my heartfelt gratitude to our distinguished panelists for sharing their expertise and making this session truly insightful. A special thanks to all our engaged audience for their thoughtful questions and participation. We hope this discussion was valuable. Thank you all once again and have a very, very great evening. Thank you.
Thank you so much.
Thank you. Thank you,
Thank you,
Devesh.
everyone.
Thank you,
Thank
everyone.
you.
Thanks.
Thank you very much. It's been a pleasure.
Thank you.